As a real estate professional, we need to know a lot about financing. Now, we don't have to be experts in financing, but it wouldn't hurt. Listen, you don't have a deal unless the person who's making the purchase has the money to buy. And when it comes to a transaction, there's a lot of people involved. There are loan officers or mortgage loan originators. There's you, the real estate agent. There's your client and maybe their spouse and maybe their kids or who knows what. There's home inspectors. There's appraisers involved. But in terms of the eyes of your client, buyer or seller, landlord or tenant, they're looking at you. And so you might not be an expert in all these areas, but at least you know enough to be so you can explain what's going on. And that's what this is all about. You might at some point in your education, you say, well, how come I got to know so much about financing? Aren't there mortgage loan originators? Well, if you don't know a lot about financing, I don't think you're going to make it in this career. All right? It's a big, important thing. And the folks you're working with are going to want to know that you know what's going on and you can explain all the different things that are happening to them. All right? All the things they're going through to try to get this loan. So the more you know about it, the more you can explain it, the more you can say, yep, this is the way they do it, this is okay, the more confident that client's going to be with you. Let's take a look at a couple of things. First of all, this idea of title theory versus lien theory. This applies to the lender. All right? So title theory versus lien theory. In one case, when you get a loan, you're going to give you're going to give a mortgage to the lender, and they're going to place a lien on the property. That's lien theory. In title theory states, the lender doesn't just have a lien on the property, the borrower actually gives title, legal title, to the lender. They can't hold it, they put it in the possession of a trustee. That's title theory. In general, the lender has more power in title theory states. That's my experience anyway. In title theory states, the borrower, the mortgagor, actually grants legal title to a trustee. Now, the trustee is working for the lender. The benefit of the beneficiary of the trust is the lender. The trustee holds title on behalf of the lender. The borrower retains equitable title. Remember, all I have to do is fulfill my obligation per this mortgage contract, and I'll end up with legal title. Legal title is then returned to the borrower when the debt is paid in full. Title theory. In a lien theory state, there is no trustee. So if you think about it from that perspective, in title theory, there's three parties: the borrower, the lender, and a trustee. Three parties. In a lien theory state, there's just two parties. There's no trustee. In a lien theory state, the borrower holds legal and equitable title. So you don't give legal title to the lender. What you give to the lender is a mortgage, and that allows the lender to place a lien on the property, and that's a specific lien. The lender has a specific lien on the property as security for the mortgage. So your state may be one or the other. In my state, both are allowed, but in practice, we're a lien theory state here in Minnesota. So you just have to check, talk to your broker and find out, talk to the loan officers and find out what kind of loans are generally made where you're going to be doing business. So whether it's a mortgage or a deed of trust, the function's the same. This is key. Mortgage, deed of trust. I want you to do this, gang. Highlight mortgage, deed of trust. Highlight mortgage or deed of trust. Third time I'm telling you to do it. Highlight mortgage or deed of trust. Then go down and highlight A, security for the promissory note. Security for the promissory note. What is the mortgage or deed of trust? Answer, security for the promissory note. It pledges the real estate as collateral for the debt. This is a key point. The function of a mortgage or deed of trust is to provide the lender with security for the promissory note that you gave the lender. It's an IOU. Collateralizes the debt that you're borrowing. States using deeds of trust often use non-judicial foreclosure, also known as power of sale clause. Like I said, the deed of trust generally has quite a bit of power. The lenders have quite a bit of strength in those particular states. Those using mortgages might use non-judicial or judicial. in a foreclosure process. Simply put, it's harder, more expensive, takes more time to go to court. That's judicial, going to see the judge, going to the court system. Judicial foreclosure. Non-judicial means in the contract, in the mortgage contract, deed of trust contract, it says, hey, if you default, I don't have to sue you. I don't have to take you to court to get the right to foreclose. We're going to skip that phase. Non-judicial foreclosure. So in your textbook there, your workbook, you can see an example of a promissory note. I'm going to go over it real quickly. Identifies the property. Yada, yada, yada. There you go. Promise to pay. In return for the loan I've received, I promise to pay back the loan, must be a $100,000 loan, plus interest to the order of the lender. Now, gang, this is a little bit more of a simplified version than you're actually going to see homeowners applying for. This is there for demonstrative purposes. The lender is identified here. The lender, or anybody takes this note, check that out. See, it's the lender or anybody else who takes this note. These types of notes are generally transferable. Anything that produces income, like somebody making payments on the loan, anything that produces income has value and can be sold. And it's very common for the company that originates a loan to sell it to somebody else, perhaps the secondary mortgage market. That gets them more money. They can come back and originate some more loans. So go ahead and transfer it. When you see the note allows for that, is entitled to receive payments under this note. They're going to be called the note holder. Here is the interest rate. The monthly payment is $600, all delineated in the note. I'm going to make my payments on the first day of each month, beginning whenever this loan takes place. It's always the beginning of the month after you make a loan, but it's not the next beginning. It's the first month. So if you make a loan on the 15th of the month, your first loan payment's not going to be due on the 1st of the next month. It's going to be due on the 1st of the following month. On the following month. Interest is paid in arrears, not in advance. I will make my monthly payments on the first day beginning in whatever month we determine that's going to be. The balloon clause. At the end of the loan, the lender's going to give me balloons? No, it's not what it means. We all know balloons are fun, but this balloon means there's a final payment due. So if on the maturity date I still owe any amount, I will make that payment in full on that date. In a partially amortized loan, you're not going to fully pay off the balance of the principal. You're going to have a balloon payment. If you have an interest-only loan, you're not going to pay off any principal. The balloon, the principal payment, is going to be due at the end of the loan period. There's the bottom half. We got whether or not there's a prepayment clause. So it says no prepayment penalty clause. I would probably just say, what's the prepayment clause? The prepayment clause will say whether or not, if I prepay this loan, if I pay this loan off before the loan term, is there a charge? And this one says no, there's no prepayment penalty. I have the right to make payments of principal and interest at any time before they are due. I can make a full prepayment and I won't get charged a penalty. That's more common now. Back in the days of predatory lending, it was common that there'd be prepayment penalties in these loans. Remember how you'd refinance so much? Now, you folks going into commercial real estate, it's very common for commercial loans, partially amortized loans usually, to have a prepayment penalty if they pay off that loan quickly. Late charges delineated. If you make partial payment, they're always going to pay themselves first, interest. The remainder will be applied to principal. Here's the last important thing I want to tell you about, the acceleration clause. If I do not pay the full amount of each monthly payment, I'm in default. I owe you $600 a month, I didn't pay, I'm technically in default. Now, if the default is large enough, at the lender's request, they can say, you know what, I know it's a 30-year term, but it's no longer. I want my money now. I'm going to accelerate the due date. I'm going to accelerate the due date. May require me to immediately pay the full amount. That's the acceleration clause. And the last thing they'll say is, hey, there is a mortgage or deed of trust that's acting as security for this promissory note. Let's talk a little bit more about the promissory note. A promissory note is a legal instrument that provides evidence of the debt. All right, so what does the lender want to do to secure that promissory note? It's going to be secured by the mortgage or deed of trust. So remember again, the mortgage or deed of trust provides security, collateralizes the loan for the debt, and that loan debt is evidenced in the promissory note. So it's evidence of the debt, secured by a mortgage or deed of trust. The promissory note is held by the lender until that loan is fully repaid. It's not recorded. The mortgage will be recorded, but the note will not. The note doesn't create a lien. It's just evidence of the debt. Some of the key elements, as we saw when we looked at the graphic, a personal promise to repay, for the borrower to repay a fixed amount each month in terms of the payment. Now, the signature of the borrower, the promissory note's not a contract, so the lender does not sign it. So there's your starred item, there's your highlighted item. The lender does not sign the promissory note. The borrower signs the promissory note. So it's not a contract, just a IOU. The special provisions, the thing you're going to want to know about this is the acceleration clause. This is also going to appear in the mortgage, by the way. So a clause that appears in both the note and the mortgage is the acceleration clause. And what it says is, yes, it's a 15-year loan. Yes, it's a 20 or 30-year loan. However, if the borrower defaults, I can call the loan due. I can accelerate that due date. And I'm going to say it's on this day, this much is due. Otherwise, I'm going to start going into foreclosure proceeding. If the borrower defaults, the lender can demand immediate payment of the entire balance, plus any interest that's due, plus any penalties that start to accrue. Promissory note alone does not create the lien in the property. That's what the mortgage, that's what the deed of trust does. Most real estate notes are negotiable and transferable, which means they can be sold. If you want to learn something new about business, if you don't already know about it, go ahead to the internet and search, loan buying or buying notes. So you can sell promissory notes. Mortgages can be sold. Anything that produces income has value and generally can be sold. All right, let's look at mortgage and then mortgage and deed of trust a little bit differently. Once again, they're security instruments. These are instruments that pledge the property as security for the debt. The IOU says, I'm borrowing this money to buy this property. It's the mortgage or deed of trust that pledges the property as security for the debt. It collateralizes the loan. The actual word is hypothecate. You don't have to remember that, but it's a fun word to use. Breaks the ice at parties, impresses your friends and neighbors. Hypothecate means that you're pledging the property as security for the debt. So the mortgage or deed of trust creates a lien when recorded. It's a very powerful lien, a lien on the property. It's an encumbrance, all right? It's a cloud on title, so when the buyer buys your property, they're going to demand that you pay off the loan before they take title. And that's what happens at the closing table. Creates payment obligation to pay off the principal and interest. Interest on the majority of home loans is simple. It doesn't compound. Compounding interest is paid on a bank account. When you're paying interest, it's typically not compounded. So go ahead and highlight and star that. So there's two key points on this slide. We've said it before, we'll say it again. What's the purpose of a mortgage or deed of trust? Look at number one. It pledges, hypothecates the property as what? Key point, security for the debt. Where is the evidence of the debt? It's in the promissory note. Key point number one. Second important point, interest that's paid on mortgage loans is not compounded interest, it's simple interest. So both of these documents, both of these instruments, mortgage deed of trust allows for foreclosure if the borrower defaults on the note. A mortgage is a two-party instrument. The borrower is the mortgagor. Why? Because the borrower gives a mortgage to the lender. The lender is the mortgagee. And if you've forgotten about it or if you haven't heard about it before, a key way to remember this is you'll notice there's two O's in mortgagor and there's two O's in borrower. So if the question says, hey, if you ask the question, what do you call the borrower? You go borrower, two O's. You call the borrower the mortgagor, because there's two O's in mortgage, or there's two O's in borrower, and there's two E's in lender, and we call the lender the mortgagee. O's giveth, E's receiveth. The way financing work is you give a note, you give a mortgage to the lender in exchange for getting a loan from the lender. So the borrower is the mortgagor, the lender is the mortgagee. Here's a fun graphic. So there's the borrower, mortgagor, there's a lender, mortgagee. So the borrower provides a note and a mortgage. That mortgage provides security for the note. The note is evidence of the debt. In return, if everything goes well, the lender gives you the money you need to buy the property. Deed of trust, on the other hand, is a three-party instrument. The borrower is the trustor, the lender is the beneficiary of the trust, and the trustee is the person who's going to hold legal title. It used to be that lenders did this. If you ever read Grapes of Wrath, Tom Joad gets out of prison, he comes back home to the family farm. Dad, it's your farm, they can't take it from you. And Tom Joad's dad says, it ain't my farm, Tom. It's the lender's farm. They're the ones that hold legal title. Well, that's been pretty much outlawed. And so the lenders can no longer hold legal title. They have to have somebody else hold it on their behalf. That's the trustee. Now, some states require that to be a public official. Other states allow it to be a non-public official. It just depends on what state you're doing business in. So here's a graphic of how the deed of trust works. So the borrower, also called in this case the trustor or the grantor, the borrower gives a note to the lender. And the lender says, hey, great, thanks for that evidence of the note. Now we want something that's going to securitize that note, something that is security for that debt. And we don't want a mortgage, we want you to give a deed of trust to a trustee who's going to hold that deed on our behalf. Going to hold that legal title on our behalf. You see, we're the beneficiary of the trust, which is being managed by the trustee. So you essentially granted legal title to the trustee who holds legal title on behalf of the lender. And if you do all this, then the lender says, then we give you money. All right, so that's the three-party system in a deed of trust. Now, at the end of this, if you pay off the loan and everything goes well, that trustee is going to reconvey legal title back to the trustor borrower through what's called a reconveyance deed. A reconveyance deed. So item 6, kind of finishing up this talk on mortgage and deed of trust, at least this portion of it. Like all contracts, a mortgage requires the essential elements of a contract and must be in writing and signed by both parties, lender, borrower, to be valid. Let's identify some of the provisions that a mortgage and deed of trust would have. So these are common to both of those instruments. So the mortgage deed of trust defines the rights and obligations of both parties. Just like the note, the mortgage deed of trust is going to contain an acceleration clause, which allows the lender to demand full payment in case of default. So the way it works is you missed your payments, you stop making payments, you're in default. You've defaulted on the note. All right? And so the lender says, I'm going to invoke the acceleration clause that appears in both the note and the mortgage, and I'm going to say, you owe me my money. Pay up. And you go, I don't have that kind of money. Okay. Then we're going to exercise the right you gave us in the mortgage and deed of trust, and we're going to start a process that allows us to take your property, foreclosure, take your property, and we're going to sell it in an attempt to pay off the loan. So that's how the whole thing sort of works. Acceleration clause. Lender can call the loan due in case the mortgage is violated, most often because of not paying the payments of principal and interest. So there's no sense entering into a debt agreement unless a debt agreement when they're going to put a lien on the property or they're going to actually hold title. You go, wait a minute. If I'm going to allow you to put a lien on the property in a mortgage, if I'm going to allow you to hold legal title so I can get this loan, I want to guarantee that I'm going to get title back on that deed of trust. I want to guarantee that that lien will be removed from the public record because I know y'all are going to record your mortgage, and I know that creates a lien on my property, and I want you to agree to remove that lien. I want a satisfaction sent to me, and I'm going to record that bad boy in the public record. So it's going to say loan created, and then several years later, loan destroyed, or I'm sorry, loan lien created, loan lien destroyed, satisfied the debt, defeasance clause. When the debt is paid in full, the lien must be removed, and they do that by sending a satisfaction of lien or satisfaction of the encumbrance to the mortgagor, and the mortgagor is going to want to make sure they record that. The mortgagee provides a satisfaction. The trustee in a deed of trust situation provides a deed of reconveyance, which is conveying that legal title that was given to the trustee back to the borrower. Now, you got to make sure these things are recorded. Satisfaction or reconveyance deeds proves payments are made in full and are recorded. There was a time back in my investment history where I failed to record the thing. I had a short-term loan or something, I can't remember, but I had this property I was working on, and I paid off an encumbrance. They sent me the satisfaction. I finished the renovation. I go to sell the property, or I think that was the case, and the person says, well, there's a lien on the property. I go, no, there isn't. I own it free and clear. No, there's a lien. I go, oh my goodness, I forgot to record the satisfaction. So in terms of the public record, there's still a lien on the property. So I had to record the satisfaction so the buyer could get financing to buy my property. So the borrower wants to, the borrower wants to make sure that that satisfaction or reconveyance deed gets recorded, and that releases the lien. Due on sale clause. You know, you see this sometimes in late night infomercials and stuff, or you might see it if you're talking to especially neophyte investors. They think they can go ahead and just sell you their property. Now, they own the property. They used a mortgage to buy it. And they think they're going to sell you the property. They're going to charge you a little bit more than they're paying. And they'll say, I'll sell it to you on a contract for deed. And if you're uninitiated, if you're naive enough, you're going to buy this property, and there's a mortgage underneath that property, all right, with a due on sale clause on it. So if I buy a property and use a mortgage and I sell my property to you, but I don't pay off the loan, chances are I'm in violation of the mortgage. Why? Because mortgages, deeds of trust contain a due on sale clause, which says if you sell the property, you got to pay us back. Now, the only exception to that is if you tell us that somebody wants to assume your loan, and we'll maybe allow them to assume if they qualify. But you can't just take out a loan, buy a property, sell the property, and not pay back the loan. Provides that when a property is sold, the lender may demand immediate payment of the outstanding debt. 99 times out of 100, they usually do. So you'd have to have lender consent for someone to assume the loan that you took out to buy the property. The due on sale clause, also called the alienation clause. Remember when we sell our property, when we leave our property, we leave our home, we alienation. So there's voluntary alienation and there's involuntary alienation. So in this case, you're selling the property, you've sold the property, you're alienating yourself, you did a voluntary alienation. And when you do that, the due on sale clause, which equals same thing as the alienation clause, kicks in and says, lender says, you sold the property, you owe us our money. Prepayment clause. This will establish whether or not the lender can charge you a fee for paying off the loan early. Not very common at all in residential loans. You might see it here and there. Pretty common, like almost all the time, in commercial loans where there's a prepayment penalty for paying off the loan early. But the mortgage will address that with the prepayment clause. Starred, highlighted. Power of sale clause. Not every state allows this. My state does. Power of sale, that's an agreement within the mortgage that says if you violate the mortgage, we don't have to go to court. Power of sale clause, we can go through non-judicial foreclosure. So it's an optional provision in a mortgage if allowed by the state law. It's standard in deeds of trust. It gives the trustee mortgagee, the lender, the power to foreclose without going to court, going to non-judicial foreclosure. I don't want you to think, I'm going to go back a second, I don't want you to necessarily think that's a bad thing. Because if you're in default on the loan, I mean, you really don't have a leg to stand on unless the lender screwed up somehow. You've broke the contract. And what's going to happen is you're going to start owing the fees. And if they have to go to court, it's just going to be tacked on to what you owe them. So a lot of times it's not necessarily a bad thing to agree to have a mortgage with a non-judicial foreclosure clause or the power of sale clause. Other reasons here are the reasons for acceleration, i.e. how you can default on a mortgage. On a note, you can only default by not making your payments. On a mortgage, you can default, and I think it's 6 ways. You can not make your mortgage payment of principal and interest, or you don't pay the taxes if you're paying them directly and not going through the lender. I like this one the best. You remove the improvements without the lender's permission. So they send somebody by to inspect the house, and they go, well, what the heck, where is it? It's an empty lot. You see, if they foreclose and the building's not there, all they're foreclosing on is a piece of dirt, you see? So you can't remove the improvements without the lender's permission. Or you let insurance coverage lapse on the property. These are all ways to default. Waste. Waste is if you let a property deteriorate to such an extent that it lowers the value, they foreclose and they can't sell it for enough to pay back the loan. That's called waste, all right? So would include deferred maintenance that lowers the value of what is owed, lower the value on the property lower than what it is owed. And then we've got the alienation without consent. That's when you violate the due on sale clause. I'm just going to tell you a little story about waste. I had a nonprofit stint in my lifetime, in my career. And what I did is I worked for Outward Bound. I was leading wilderness journeys throughout the country. I did this for about 4 or 5 years, and sometimes it was seasonal, and I would do consulting work for nonprofit groups, commercial nonprofit groups. A lot of those had housing stuff, so once in a while, I'd have somebody go down to the county recorder's office, find out if there was a loan on the property, find out who the lender was, take pictures of the property, and I'd send it to the lender saying, hey, look what this guy's doing, this landlord's doing with your property, letting it go to waste. It never worked. I thought maybe put a little pressure on the out-of-town landlord to take care of the property a little bit better, but it's always kind of fun to do anyway. All right, remember, alienation without consent and waste are the ways to default on a loan, one of 6 ways. The one to highlight in this group is waste.